If you're a landlord, property manager, or tenant in the United States, understanding eviction notice requirements is absolutely essential because the notice is the foundation of the entire eviction process. Get the notice wrong, wrong timeline, wrong format, wrong delivery method, wrong content, and your entire case can be thrown out of court. Every state has specific rules governing what type of notice is required, how many days the tenant gets to respond, and exactly how the notice must be delivered. That's what this series covers. At tenantscreeningbackgroundcheck.com, we've created individual videos and comprehensive written guides for all 50 states, Washington, D.C., and Puerto Rico, breaking down the notice requirements that apply in each jurisdiction. Whether you're a landlord preparing to take action or a tenant who just received a notice, knowing the exact rules in your state can make or break your case. So let's start with the basics. In virtually every state, before a landlord can file for eviction in court, the landlord must first serve the tenant with a written notice. The type of notice required depends on the reason for the eviction, and the three most common categories are non-payment of rent, lease violations, and no-cause termination. For non-payment of rent, which is the most common reason for eviction nationwide, every state requires the landlord to give the tenant a specific number of days to pay the overdue rent before filing in court. This is called a pay or quit notice, a demand for rent, or a notice to pay or vacate. The terminology varies by state, but the concept is the same. Pay what you owe within the specified period, or the landlord can proceed with eviction. The pay or quit timelines vary dramatically across the country. At the shortest end, states like Utah, Montana, and Wyoming require just 3 days. Kentucky allows just 7 days in counties that have adopted URLTA. North Carolina gives 10 days from when rent becomes due. Virginia requires 5 days. Texas doesn't specify a minimum, just that the landlord must make a demand, and if the lease doesn't specify a period, courts generally require at least 1 day. At the longer end, states like Wisconsin require 14 days. Rhode Island requires 15 days. Massachusetts requires 14 days. Vermont requires 14 days. And some states have recently extended their timelines. Washington State, for example, now requires 14 days for a pay or quit notice, up from the 3 days it required for decades. Most states fall in the 3 to 7 day range for non-payment notices. The 5-day notice is the single most common standard across the country. An important distinction that varies by state is whether the tenant can cure the non-payment by paying during the notice period, and if so, how many times. Most states allow the tenant to stop the eviction by paying the full amount owed within the notice period. But some states limit how many times a tenant can cure. Arizona allows the tenant to reinstate by paying, but only once per 12-month period. Virginia's pay or quit notice doesn't require a cure opportunity after the first instance in certain repeat non-payment situations. Understanding whether your state allows unlimited cures or limits them is critical for handling chronic late payers. For lease violations other than non-payment, things like unauthorized occupants, pets, excessive noise, property damage, or other breaches of the rental agreement, most states require a cure or quit notice. This gives the tenant a specified number of days to fix the violation before the landlord can proceed with eviction. The cure periods for lease violations are generally longer than for non-payment. Many states provide 14 days to cure, including Kansas, Kentucky, in Uvalde counties, and several others. Some states provide 30 days. A few states use shorter periods. Arizona requires 5 days for health and safety violations and 10 days for other lease violations. For violations that cannot be cured, such as serious criminal activity, drug manufacturing, or substantial deliberate property damage, many states allow the landlord to serve an unconditional quit notice with no opportunity to cure. The tenant simply has a specified number of days to vacate. California allows a 3-day unconditional notice for incurable breaches. Arizona allows immediate action for drug-related criminal activity. The specific grounds that qualify as incurable vary by state, and landlords should know exactly which violations their state considers serious enough to skip the cure period. For repeated violations of the same type, many states have escalation provisions. If a tenant violates the lease, receives a cure notice, fixes the problem, and then commits the same violation again within a specific window, typically 6 months, the landlord can serve a termination notice without providing another cure opportunity. States like Kansas, Kentucky, Arizona, and many others include this repeat violation provision. It prevents the frustrating cycle of violation, cure, and immediate re-violation. For no-cause termination, ending a month-to-month tenancy without alleging any fault, the notice requirements also vary significantly. The shortest no-cause periods include North Carolina at 7 days, some week-to-week tenancies at just 2 to 7 days, and a handful of states with 15-day standards. The most common standard is 30 days notice. This applies in the majority of states for month-to-month tenancies. Some states require longer no-cause periods. Oregon requires 30 days for tenants in the first year, but 90 days after the first year. Washington requires 60 days. California requires 30 days for tenants in the unit less than 1 year and 60 days for tenants who have been in the unit 1 year or more. Though California also requires just cause for tenancies over 12 months, so a no-cause notice isn't available for long-term tenants. And an increasing number of states and cities have eliminated no-cause termination entirely for certain tenancies. California's statewide just cause eviction law, New Jersey's Anti-Eviction Act, and numerous local ordinances in cities across the country now require landlords to have a specific legal reason to end a tenancy. In these jurisdictions, you can't simply give a no-cause notice to a tenant you'd like to remove. You must identify a qualifying ground. Now let's talk about how the notice must be delivered, because improper service is one of the most common reasons eviction cases get dismissed. Every state has specific rules about how notices must be served on the tenant. The most common acceptable methods include personal delivery, handing the notice directly to the tenant, substituted service, leaving the notice with another adult at the tenant's residence and mailing a copy, posting and mailing, affixing the notice to the door and mailing a copy, and certified or registered mail. Some states require the landlord to attempt personal service first and only allow alternative methods if personal service fails. Other states allow any of the authorized methods from the start. A few states have added electronic service options, including email or text, under certain conditions, though this is still uncommon and typically requires the tenant's prior written consent. The consequences of improper service can be severe. If the landlord uses a delivery method that isn't authorized by the state statute, the notice may be invalid, and the entire eviction case built on that notice can be dismissed. This is one of the most common tenant defenses in eviction proceedings, and courts scrutinize service carefully. Always use a delivery method specifically authorized by your state's statute, and always document how and when the notice was delivered. The content of the notice also matters. Most states require the notice to include specific information: the tenant's name, the property address, the reason for the notice, the specific amount owed for non-payment notices, the specific violation for cure notices, the deadline for compliance, and a statement of what will happen if the tenant doesn't comply. Some states require specific statutory language to be included in the notice. California, for example, has extremely detailed content requirements, including a notice that must state the exact amount of rent owed without including any non-rent charges, and failure to comply with these requirements invalidates the notice. One area where states differ significantly is what happens after the notice period expires and the tenant hasn't complied. In most states, the landlord then files an eviction action in court, called an unlawful detainer, forcible detainer, summary ejectment, or summary process, depending on the state. The court schedules a hearing, the tenant has the opportunity to respond and raise defenses, and if the court rules for the landlord, a judgment for possession is entered. The speed of this court process varies enormously. Arizona schedules hearings within 3 to 6 days of filing. North Carolina's summary ejectment hearings are typically scheduled within 7 to 10 days. Texas courts can move quickly as well. At the other end, New York City's housing court can take months. California's unlawful detainer process, while designed to be expedited, can take 3 to 6 months in contested cases in large urban courts. New Jersey's process under the Anti-Eviction Act can also extend for months. Some of the most important state-by-state differences we cover in this series include whether the state has adopted the Uniform Residential Landlord and Tenant Act, because URLTA states follow a standardized framework, while non-URLTA states may have less predictable procedures. We cover whether each state allows the tenant to cure non-payment, and if so, whether there are limits on repeated cures. We cover the specific grounds that qualify as incurable breaches in each state. We cover the required notice content and any state-specific language requirements. And we cover the anti-retaliation protections, because serving a notice in response to a tenant's protected activity is illegal in every state. Every state guide in this series covers the exact timelines, delivery methods, content requirements, and court procedures that apply in that jurisdiction. We've included information about local variations where cities have enacted their own requirements on top of state law. For landlords, the practical takeaway is simple but critical. Use the correct notice with the correct content delivered by the correct method with the correct timeline every single time. There are no shortcuts. A technically deficient notice wastes your time, delays the process, and can result in your case being dismissed. Many experienced landlords and property managers use state-specific notice templates reviewed by an attorney to ensure compliance. For tenants, the practical takeaway is equally important. Read any notice you receive carefully, count the days precisely, know your rights to cure, and understand that the notice is not the eviction. You cannot be physically removed from your home based on a notice alone. Only a court order, followed by enforcement by the sheriff or marshal, can result in physical removal. If you believe the notice is defective or retaliatory, you have the right to raise those defenses in court. To find your state's complete notice law guide, visit tenantscreeningbackgroundcheck.com and look for our eviction notice laws by state page. We have all 50 states, Washington, D.C., and Puerto Rico covered with detailed written guides and video walkthroughs. Subscribe to our channel to get every state in our notice law series, plus our habitability laws, lease termination laws, rent increase laws, and tenant screening compliance series. And if you need a fast, affordable tenant screening or background check, visit tenantscreeningbackgroundcheck.com. No account needed, results delivered quickly, and fully FCRA compliant.